There are a lot of different directions we can take in negotiating and in trying to settle a case. Most DUI cases in Marin County in the Bay Area do not go to a jury trial, which means there's a negotiated plea where your lawyer would show the mitigating factors to the prosecution, to the DA, to try and get them to dismiss the case or reduce the charges. Every DUI case is different. Many are similar, but there can be so many different areas of the spectrum with DUIs. It can be, this might not be your first case. This might be a really high alcohol level. There could be an accident. There could be injuries. There could be, there could be drugs involved. There could be high speed. There could be kids in the car. There could be so many different things that happen with these cases that every case has its own angle for negotiating. But what's really important for us from the beginning is to make sure that our client, you, do not get in any more trouble and take steps to show that that you get it and that this is not going to happen again. So in a case that, with a high alcohol level or an accident or something like that, a case that we're trying to mitigate the damage where we don't think we're going to be able to make the charges go away, it's important that you do certain things to show the court, the prosecution, the DA's office that we're going to negotiate that you are serious about making sure this doesn't happen again. So things like self-help meetings, AA, therapy, residential or outpatient programs sometimes in more extreme cases, and for people that have serious alcohol or drug issues, can be very helpful in negotiating a disposition on your DUI case. Things that we talk about with the prosecution, what I like to do is get all the evidence I can and then negotiate. So that means once I enter a not guilty plea on a case in Marin, I'm getting the complaint against my client and the initial police report. I'm going to always be asking for additional information from the DA's office, video, audio of the driving, of your contact with the officer. If there's a blood draw, video of the blood draw. I want records on the breath machine, the blood machine, calibration records, maintenance records, accuracy checks, all of these different things that can, where I can find that something may not have been done properly. There may be a problem with a machine. Imagine that, a machine, a computer, having an issue. We've never seen any errors in machines, have we? Of course not. So I look at everything, and then when I see what I have to put forward, then I'm negotiating with the DA's office and letting them know what factors I think should lead to them dismissing a case or reducing charges. It's very rare when the DA's office in Marin County or any other county in the San Francisco Bay Area will actually dismiss a DUI case. It does happen sometimes, but typically the only way that something like that's going to happen is through our investigation and showing them that they do not have the elements of a DUI, that it would be tough for them to go in front of a jury and prove the elements of the case. One is driving and the other is either impairment or being at or over a .08. A lot more information here, a lot more answers that I can give regarding how the factors that are considered in negotiating a plea deal or a settlement on a DUI case in Marin County. These are just some of them. And let me just leave with one other factor. When we do get charges reduced in most DUI cases in Marin County, it's typically when we have a lower alcohol level, something closer to the .08 limit usually has a better chance in other cases of getting reduced to a lesser charge. That's a big chunk of what goes into negotiating these cases in Marin County.